Hey guys, it's Mo from Mo in the Deep End, and I wanted to bring you guys the transcript of the October 19th in chambers, meeting that Judge Gull had with all of the attorneys, but not Richard Allen, that led to her accepting the resignation or the oral promise of a resignation from both Attorney Baldwin and Attorney Rossi. So I thought we would go over that. Now, in chambers were both Attorney Baldwin and Rossi, and then, I'm sorry, Mc, Attorney McLeland and James Luttrell, the Carroll County prosecutor and deputy prosecutor. So typically, you would also have the defendant as he is the one being represented. Now, this did not happen, which is one of the many things that this Indiana Supreme Court is looking at. But this is something that the Indiana State Supreme Court did ask Judge Gull to provide to them, and it was recorded from the state or from the you know court reporter, so I thought we would go over it. The Honorable Judge Francis Gull and, the court reporter. So first, Attorney Nicholas McLeland, Judge, I wanted to do some introductions. I finally got approval from our counsel to hire a paid attorney to help me, so the court. Okay, Mr. McClelland, small town local government. So this is Jim Luttrell. He is a retired prosecutor from Grant County, and he has decided or agreed to come on board the court. Okay, have a seat. Mr. McClelland, he signed the oath to my office, the court. Okay, so the court already seems to be on a mission and kind of cutting the prosecutor off, Mr. McClelland off. Mr. McClelland. And all that, I am going to handle a written appearance. Attorney James Luttrell. Nice to meet you, Judge. The court. Nice to meet you, Jim. So I don't like this subtle, kind of putting him in his place of saying his first name and not, you know, Mr. Luttrell. She calls him Jim. Mr. McClelland, next week, the court, okay. Mr. McClelland, or maybe tomorrow if I have time, Judge, if I get it done. The court, okay. Mr. McClelland, but he will be entered in and we are trying to get him up to speed. The court, okay, well, good. Attorney Bradley Rossi, well, I'm the one that kind of asked to huddle up. So if you want me to lead or if you want to say some things, I'm okay with whatever approach you want to take here. The court. Go ahead. Well, I think the court. I've got Jody, got our portable FTR going, so just that we've Mr. Rossi. Okay, that's fine. The court got a record. Mr. Rossi, obviously, I'm happy to hear that the court's going to make some decisions on the pending pleadings today. The court. Hmm. Affirmative response. Mr. Rossi. I assume Andy feels the same way. You know, it's time to kind of get some closure, if you will, with regard to those items so that we can move forward. It's probably obvious that the tension from our side is coming from, the words, quote, disqualification, end quote, that were murmured in the phone conference that we had a couple of weeks ago. I'm assuming you understand how that kind of raises the intensity level of circumstances. And I guess if I have a concern today, it's that, we're going to go out on the kind of in public, so to speak, in the courtroom on the record and have a discussion about an ongoing investigation. And I, that's kind of what I kind of gathered from the email. I think you invited Nick to talk about that if he wanted to. The court. Mm-hmm. Affirmative response. Mr. Rossi. And, it makes me feel a little uncomfortable because I don't know. First of all, there are no pleadings that are pending, whether they are motions to disqualify or contempt citations, or whether they might be that really frame any of the issues. And I have no problem. I mean, I don't have any problem talking about this stuff privately on the record in in an ex parte type confidential hearing. I just think it's a little difficult to expect that there will be a kind of structure to the idea of, quote, "Hey, there's an ongoing investigation and just tell us what's going on," end quote. And I don't know what's that it has any relevance to what we're really trying to accomplish today. And I don't know why Nick would want to talk about an ongoing investigation in public. Nick is the prosecutor, obviously. Knowing that in itself could be damaging to their circumstances. And so we're lawyers, we're used to having issues framed, we're used to having an opportunity to prepare. And I don't have anything to hide. I don't, I know he doesn't have anything to hide. You may have you've maybe gathered that we've cooperated. We ran into state police posts, our prospective post, if you will, and I had someone advise me of my rights, and I waived those. I gave a formal statement, he did the same. And I'm not sure that we're going to benefit or that this will be productive just to open floor this. That's my biggest concern today. The court. Mhm. The court is being very verbose today. Affirmative response. Attorney Andrew Baldwin. I'm more of the due process side. I'm not really sure what will happen, but I just don't know. I don't know what's going to happen, and I would like the opportunity to know what's going to happen and prepare for what they're claiming or whatever before it happens. And I don't want to say ambushed, but it's hard for me what do what to do when I don't know what's happening. There's not a pleading we can respond to, things like that. So, you had indicated that, when Nick said, I don't know if he said the word, quote, disqualification, end quote, but the court, oh, he did, Mr. Baldwin. Was it that word? The court. Mhm. Affirmative response. Mr. Baldwin. Okay. I didn't know if he had just said it in more of a generic way. The court. Mm-mm. Negative response. Mr. Baldwin. And your response was, I'm leaning in that direction, quote unquote, or something along those lines. The court. Mm-hmm. Affirmative response. Mr. Baldwin. And so that's, a cause for concern. I mean, we're still wanting to try this case in January. And I'm willing to, we have made changes at my office that will prevent this from ever happening again. And we take directives from the court. We can, we're locking down every single thing on Delphi. It's in a dedicated room. We put locks on our conference room or the war room where this guy went. My friend went in and did this without my knowledge. And that and no document, whether it's benign or something super, like a crime scene photo, is ever going to be left alone for a single solitary second ever again. So, I'm hoping that something that the court, can say, quote, "All right, that's fine," end quote. And let's just get on with the trial, but I'll shut up now. The court? Anything, Nick? Mr. McClelland. Judge, I guess my plan today was to give the court a summary of the investigation. I've got witnesses here and exhibits to present that go toward the investigation. I'm more than happy to hand those over to the defense. I know it may harm the investigation, but I think it's important that the court hear these things. I guess at the heart of it, inaudible, investigation, I think it's important. I think that it's important of you hearing is outweighed by that. So I have those things. I'm concerned that the leak is not just a one-time leak. The evidence we have shows it's an ongoing leak. However, it's being done, and it's just what's next? That I have an issue. What's next? I mean, I've spent the past 17 days investigating this night and day when I should have been focused on preparing for a trial. And when I say night and day, I mean phone calls at 2 a.m., 3:30 a.m., night and day. So that's where I am. I'm at judge. Again, I'm an officer of the court. I report to the court what I know, and that's kind of where I see my role. The court. Okay. Mr. Rossi, this is starting to scream due process to me. I haven't seen any of these exhibits, and I don't really, frankly, I don't know anything about any of this. I'm not distancing myself from Mr. Baldwin. I'm just saying I have no connection with any of these people, okay? And the idea that somehow the prosecutor is going to get to roll out a bunch of statements and exhibits, testimony without us having any forewarning or any idea, any way of scrutinizing that seems a little outside the boundaries of due process to me. Plus, again, I get back to what is the relevance to what is going on in this case? Why are why we are are we going to use an open courtroom to air an ancillary matter? It's not really connected in any way at this point to the proceedings that are ongoing, whether it's the Franks issue or anything of that nature. And I will tell you this, I am prepared to show the court this. I would rather do it in private. This problem has been a problem from the very beginning. I have 10 pages of a deposition transcript in this file from my deposition, in our deposition that I took from Trooper Holman in this case. And in that deposition, he talks openly about how there were crime scene leaks from the very beginning, unequivocal crime scene leaks. And that is as soon as this crime occurred. They were investigating information that had been released because there were lay people that were part of the search party. And the implication is, and I've got the transcript, is that those people that found the girls started to essentially disseminate or distribute information. And law enforcement essentially tried to catch up with them, but it was really too late, as you might expect. Once it gets into the hands of the public, it's too late. So he told us that, almost volunteered that information to me in the deposition. The second concern I have is that I think I shared with the court, just as an example, a week or 2 ago, someone sends me a court TV, bit, and I can assure you I've never watched one of those bits on this case. I don't even know that I've ever watched court TV. Well, sir, you're lucky. Maybe back when Simpson was ongoing, I don't know. And in that bit, Barbara McDonald is talking 2 different occasions. She mentioned how she's getting investigate or information from investigators on the ground that were at the crime scene. Let's see here. Where were we? On the ground at the crime scene. Now we can all draw implications about that, but most importantly, it's corroborated by the fact that she was holding in her hands documents that I know directly or to be directly related to the Purdue report. I mean, I saw the pictures. I know where those came from. And if, the point here is I'm going to say this maybe a little loosely, but forgive me. I don't care. I don't care that all of this stuff is out there because it's been out there for 5 or 6 years. I don't have time. He doesn't have time. He doesn't have time to sit and try to marshal all this stuff while the case is ongoing because there's no end to it. But the point is, and the court needs to have some context that this is nothing new. I'm super I lost sleep over the fact that there's a man who's dead and I don't even know, and frankly, Andy doesn't know, and it's tragic. I don't know what life circumstances he had or what surrounded this. We've not None of the information has been shared with us, but at the end of the day, what's going on out in the cyber world and in the public, as you might expect in this case, a case in this magnitude that's been publicized for 6 years is beyond our control before we even got involved. Mr. Baldwin. There's even a guy in Florida who says the guy in Texas who leaked all this stuff had received from a disgruntled Carroll County employee a whole file filled with stuff and photos included. And I haven't seen the photos that were leaked. I don't know what they are, you know? I mean, if this could be set for a formal hearing in the future where we have a chance to do it the right way, that's one thing. But, to go in there and we don't have any way to counteract anything, if I know what it is, I can quote, "Oh, okay, I know what that is," end quote, or quote, "I don't know what that is," end quote. And and in the meantime, I don't know, we can honestly this is the worst, the lowest point in my career right now because somebody did what they did to me. And that has nothing to do with Richard Allen, the court. It certainly does not. Mr. Baldwin. Richard Allen needs to have counsel there. So I didn't just want to go in there and not be able to fight back if it with the evidence that we or witnesses that we have to counteract whatever they claim they have. The court. Now she speaks. Oh, good God. Okay, here are my thoughts in no particular order. I don't know how many folks are out there, and I certainly don't wish to air publicly to the world the concerns that I have about this matter. My intent in having this hearing was to go through some of the pleadings that we have not yet decided. So I was going to start with reminding everyone about decorum, order, and reminding everyone while we're here to shut up, etc. There have been reports to my sheriff about disruptive people, and I will remind people if they are disruptive, they will be removed. My sheriff is fully prepared to execute arrests if necessary because I know we've seen in our other hearings people have been disruptive and hateful. So under the canons of judicial conduct, I required to advise people within the room that the media is here and they are filming. They are doing full coverage, so there are only 2 cameras in the courtroom, and everyone is going to get coverage from that. And then I want to talk about the pleadings. The defendant filed a verified motion for immediate transfer of custody. The state filed its response. The motion, again, has a lot of inaccuracies and some speculation. It has been refuted ably, and I think the affidavits that have been submitted by the state, and I'm going to deny the motion. The defense has filed a motion for broadcasting order. The state has filed its response. Your motion is overbroad. It's got a lot of irrelevant verbiage in it, and I'm required to consider individual requests for hearings. So I will. If the media wishes to have an individual request submitted, they know fully well how to do that. And I've provided to counsel all those requests that I have gotten so far for this hearing. So if you want to file them for particular hearings, you're certainly welcome to do that. But the media is all over this, and they know how to do this. Mr. Rossi, yes, I was just trying to understand, are you suggesting that you are going to determine that on a case by case basis or on a hearing by hearing basis? The court, hearing by hearing. So basically, this judge is saying she was going to, pick and choose which hearings she was going to let the media go into. But she definitely wanted the media here to witness her verbal beatdown of these 2 lawyers. Okay. Mr. Rossi, okay. The court, yeah. Mr. Rossi, all right. Okay. I just wanted to make sure I understood what the court. The state has filed a motion for the leave of court to subpoena the third party records. I think that was directed again to the DOC. Clearly, I can't grant that. I'm going to grant the defendant's motion to quash, but if you continue to raise his medical and mental health in pleadings, then it's fair game for that to be provided to the state. You have also filed, Mr. McClelland, a motion for future pleadings and filings to be sealed prior to being released to the public. I've not gotten a response from the defense. Mr. Rossi, can I speak on that? The court, sure. Mr. Rossi, I think it's important to note that, we've had this discussion come up before, and there was basically we decided, okay, we're done sealing stuff, we're going to make it public. I had before we filed that Frank's brief, a long conversation with the court reporter, Karen Allen, over in Delphi because I wasn't sure about Allen or Roller. I always want to call her Karen. Mr. McClelland, Allen. Mr. Rossi. Karen Allen, because I wasn't sure about the mechanics of how all of this stuff was moving from Delphi to your office, and I wanted to know that you had a setup of some kind of a website or something that people could access. I was under the understanding in speaking with Miss Allen, and I'm not blaming her for anything, but when we filed these things, they were going from them and they were hitting a button and we were filing them with Carroll County. They were hitting enter. They were sending it to you and you were essentially filtering this stuff, or at least you were seeing it before it became public. The court. Nope. Mr. Rossi. And so the way in talking with her, that's the way I understood the mechanics. So basically he's saying, uh, ma'am, Miss Judge, if you will, we are giving our documents, our filings to, the court clerk in Carroll County. And then we are, you know, she's sending them to the judge, and the judge is basically nerping them. Now, this judge is claiming that this is not happening, but Mr. Rossi is kind of saying, well, now, it seems to be we are having a little bit of failure to communicate. And so that's the way uh, in talking to her, that's the way I understood the mechanics, which I think is what happened to a pleading the other day, from what I understand. We filed something and you either put that in the queue. I think there's a way. Anyway, I tried to do some homework on that. And that's what Mr. Baldwin, I was part of one of those conversations, and that's what she said, the court. So does that need a hearing? I'm happy to have a hearing on that. I don't have a problem with a hearing on that. Mr. Rossi, well, I don't really, I guess I'm just telling you for context. That's what Mr. Baldwin, I mean, could there be a happy medium of what we file if of we file it confidentially and then the judge gets a chance to review it first, because I that's what we thought was going on anyway, but if that's not what's going on, the court, no, it's being filed confidentially if you mark it as such. Mr. Baldwin, I know. Yeah, I know that now. The court. I had my staff mark the memorandum confidential after it had been filed and disseminated to the public because the actual warrant was in there, and that's covered under a miscellaneous cause number. I'm happy to have a hearing. Mr. Rossi. Well, that is your ruling, I guess, to make sure I understand. I don't want to fight about something we don't need to argue about. The court. I haven't ruled on that. Mr. Rossi. Okay. The court. You haven't filed a response and that. Mr. Rossi. Yeah. The court. My question, do we need to have a hearing on that or do you wish to file a response? The Frank motion clearly needs a ruling, and I'm working on that. The motion and exhibits are about 1,500 pages, and there are hours and hours of interviews that have been made available that my IT staff has now cleaned to make sure they're okay. We already talked about that, and then that brings us to my concerns that I had and I raised with all of you on our phone call. And I write everything out, and this is what I intend to say in open court. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year. Mr. McClelland filed a motion for a gag order. We were all in chambers, and you assured me, gentlemen, quote, "We don't want media in our lives. We will not try the case in the media," end quote. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew or should have known that those were potentially violative of Rule 3.6 of the Rules of Professional Responsibility, but it is the press release that prompted me to issue the order December 2nd, granting the gag order until the further hearing. April 18th of this year, you filed a notice of a tort claim against the Department of Correction. You stated in the notice that it was your intent to pursue, quote, "our client's claims against you, the full amount of damages sought on the behalf of my client unknown," end quote. I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. I think that's inappropriate. May of this year, we were notified by the state of the Brandon Woodhouse arrest and the subsequent discovery of your work product. I think it was an outline that you created for yourselves with discovery. It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year. That was not revealed to anyone, not shared with the court. It wasn't shared with you, although apparently you guys knew about what was going on. Mr. Baldwin, he did not know. The court. You knew. Mr. Baldwin, I did know. The court. So then, Mr. Woodhouse gets arrested, and there we are. Grossly negligent to email that went to the wrong Brad. Your pleadings on the safekeeping order contain inaccuracies and falsehoods that were proven in the hearing we conducted in June. The evidence presented by the state clearly demonstrated falsity of your claims. That was very troubling to me. And then the last couple weeks that we've been dealing with, the state provided you discovery, and that has been severely compromised. Now we have an ongoing investigation. I'm not going to call it a criminal investigation. I don't know what it is, but it's clearly being investigated by the state of Indiana. Everyone involved has sought counsel, including you, Mr. Baldwin. You have an attorney enter a written appearance this morning. I don't want to get into the investigation, candidly. You are the constitutional authority for the state of Indiana. If you choose to pursue it, that's up to you. If you choose to abandon it, it's clearly up to you. I'm glad to hear that you've cooperated, but Mr. Baldwin's attorney has clearly shared. I don't know if you've seen his pleading. Mr. McClelland, I saw it, yes. Or I saw it, Judge, yes. I got it kind of late. He emailed it to us and then the court. Okay. Mr. McClelland, I saw it was filed on the way here. The court. Well, yeah. So he clearly shared it in his pleading, down to the fact that the individual has committed suicide. He included the fact that you left materials all over a conference room table accessible to anyone, and this was a friend of yours who apparently you have consulted with on this case. So again, it is up to you if you wish to pursue that. I'm looking at the totality of circumstances. When I look at suppression, the case law requires me to look at the totality of circumstances, and that's what I'm doing. And it pains me to say this, but the totality of these circumstances demonstrates gross negligence and incompetence on the part of the defense team. I am unsatisfied with your representation of Mr. Allen. I am gravely concerned about his rights to have a competent, non negligent representation. He currently doesn't have that right now because you have demonstrated negligence and incompetence. Now I am sharing my thoughts with you privately. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. I don't want this coming out. It's not where we need to be with this case, but I will. But you don't know that. You have just been made aware of my concerns where I'm landing. So if you wish to have a private conversation, I would encourage you to do that. I don't believe your client is here yet. No, he is not. Clearly, you'll need to speak with him as well. So, Mr. Baldwin, I'm not good at reading between the lines. The court. You're a lawyer. That's what you do for a living. Mr. Baldwin, when you say have a private conversation, are you talking the four of us or the court? I'm talking about you. I'm not accusing the state of gross incompetence or negligence. I am finding gross incompetence and negligence with you, Mr. Baldwin. So, okay. So, Mr. Rossi, forgive me. Go ahead. Mr. Baldwin, no, no. Mr. Rossi. I mean, obviously, reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will, if that's the right term. Is there a scenario where the court would accept it if I stayed on the case? I mean, I'm not. I'm a team player, and I'm not the kind of guy that just bails out on somebody just for the sake of doing it. But I think it's obvious that, he can speak differently, but I'm not as concerned to some, this is the most recent circumstances as he is. Mr. Allen is in a situation where he's going to have counsel that is, if he has new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And so I think his Sixth Amendment's rights matter. And, I'm probably the one that can at least move this thing forward with some sense of judicial economy. I don't like it, and that's not what I intend to do when I came in here today, but it would be the kind of worst case scenario on our side, I guess. And that's and so what is the opinion that the court would like to so is that an opinion that the court would like to entertain? The court, no. Mr. Rossi. So basically what you're saying is, quote, "You guys either quit on your own accord or make me fire you." That's what the court. No, I'm saying to you that this is what I plan to say in the court record when we convene at 2 o'clock. Mr. Rossi. Well, is this culmination of that you're removing us from the case? The court. I will, based on what I just shared with you. Mr. Rossi. Okay. Well, I just wanted to make sure we're the court. And I'm giving you the opportunity to have a conversation which how you want to do that or how you want that to go. I don't want to do this. I don't want to do this, but I will if I have to. Mr. Baldwin, how should we bow out gracefully, as Brad said? How would we even have a hearing? How would that go? Because we're out of the case then, Mr. Rossi. Then you're gonna go ahead and roll on a bunch of stuff without lawyers in the room? That's the court. No, I would not do that. If you decide that your best course of action is to file a motion to withdraw, you can do that today. I'll send Mr. Allen back to DOC after you've had a chance to speak with him. Mr. Baldwin, what would that happen before the hearing or after the hearing? That's the court. Your motion to withdraw would happen before the hearing. Mr. Baldwin, okay, that's what I wanted, yeah. The court, yeah, because I he has rights, and I don't want those rights compromised by having a hearing with him not having counsel. I assume if you choose to withdraw, that his financial situation hasn't changed and he would still be entitled to court-appointed counsel. I can't imagine he has the ability at this point to hire counsel. I don't know that. Mr. Baldwin, Brad and I need to go talk. The court, yes, you do. Thank you, gentlemen. Mr. McClelland, yep, thank you, Judge. Off the record, the court, thank you, Jody. The court reporter, you're welcome. The court, okay, yes. Mr. Rossi, all right. So we're kind of trying to figure out how to address this issue with very short notice, very little notice. And the first thing we did is really talk to the client. Mhm. The court? Mr. Rossi, our client is a big part of this, the biggest part of this, and he has communicated to us that he doesn't want us to withdraw from this case. He wants us to continue with his representation. He understands, I think, that he is not the gatekeeper or he doesn't have the authority to really force the court to do that. He would like to say that on the record. We've asked him if that's what he wants to do. We have suggested maybe he would do it in chambers. It's a bit difficult. It seems a little bit of a difficult position to put a man who's accused but not been found guilty, to put him in a courtroom and have him, have to speak in this circumstance with 15 minutes notice. Andy and I'm going to speak for myself. I'll let him speak for himself. I'm going to file a motion to withdraw. I don't want to do it, but I don't think I have a choice at this point. The options I've been given without any notice by the court really are either I withdraw or I'm going to be publicly shamed. That's the way I see this. And I think that this public shaming is not only there's not only a professional element to that, I think there's a personal aspect to that too. But when the media is teed up like this, and we show up here today with the court having told us we are going to conduct some business that somehow bleeds over into a forced resignation or whatever you want to, however you characterize this, that, I don't feel like I have any other choice professionally. I have a life beyond this courtroom, beyond this case, and I have a family too. I have a law practice. But I think we had been given some notice of what we were actually if this would have been framed in a pleading format or some formal disciplinary claim, which there is a process for that in our business, then we would have come in here today with an opportunity to refute some of those things that you clearly had, thought through and prepared before we got here. We didn't have that opportunity, and it's the idea I'm going to have to go in here in an open courtroom and essentially defend myself against claims that I don't agree with without any notice and without any opportunity, I think is unfair. But I also have some common sense. And me going in there and standing my ground because my clients wants me to is just going to make things worse for him. And so I'm going to withdraw my appearance and I'm going to walk out of here and I'm going to go down to my car. I'm going to call my staff and I'm going to have them prepare a motion. I'm going to withdraw my appearance, but I'm not doing it because I don't think I have. But I'm doing it because I don't think I have any other choice professionally, not because I want to, and not because my client wants me to. So again, Richard Allen, the person that he is representing, does not want him to leave. And they had all of these talks without Richard Allen there. So the person that is supposed to be paramount in this case right now was not there. And it seems like the prosecutor and the judge got buddy-buddy and had this entire thing, thought out before the defense even got there. Again, there is due process. There are procedures to fire a, terrible lawyer. There are disciplinary hearings. There are things that have to go on. If she thought that they were grossly negligent, She could bring those up in a disciplinary hearing. She could have taken that to the bar association. She could have done a lot of things, but this is terrible. Uh, Not because I want to and not because my client wants me to, and I respect the court has an opinion, but we're professionals and we can disagree. The court, of course, Mr. Rossi, and, I'm extremely, I'd say frustrated is probably a soft word, with the idea that we showed up today without any real opportunity to prepare for any of this, and I just think it's improper, and that's where I am. That's my position. The court. Well, I think we talked about when you asked for a disqualification, and I indicated on the phone conversation, I'm inclined to do that. Mr. Rossi, it was a phone conversation that's not on the record, then some follow-up emails. The court. True. Mr. Rossi, there's an informality to that. The court. True. Mr. Rossi, you also said you hadn't done any research and you hadn't, had time to talk to your senior judge and all these other things. He hasn't filed a pleading with the court either. The court, no, I'm doing this on my motion. Mr. Rossi, and I'm a lawyer who practices in a lot of courtrooms, and I've been through some disqualification actions. In 20 years, I've never had a disciplinary complaint in my life that's been confirmed, if you will, but I've seen lawyers disqualified, and there's a process for that. And it's not this. With all due respect, where you walk into someone's office, a judge's office, and they read a prepared statement to you, and essentially that statement is an indictment on my professional activities, then you're handed, essentially a sheet of paper with two options. And one of them is, quote, I'm going to go out there and shame you or you can quit, end quote. You can understand how upset that would make a lawyer. And I don't think this is the right way to handle this from a due process standpoint. So I have no choice but to, withdraw my appearance because I'm not going to go in there and take a public shaming without having any notice. That's where I am with it. Mr. Baldwin, I'm same. Withdrawing. I mirror what he said. I mean, I do appreciate giving us some advance notice. If there's some appreciation for that, I do appreciate that. But beyond that, I want to take this and finish it out. I'm stunned. I don't know what to say. I'll just say I'm moving to withdraw orally. The court. Okay. Mr. Rossi, is the court going to generate some further instructions on what's going on with all the discovery we have? And the court, I already have. Of course she did. She planned on this. This was an ambush. Mr. Rossi, all this information and the court. There's an order. I granted the state protective order on discovery. Mr. Rossi, no, I'm talking about my possession of all this information. Am I to take it to the trash can? Am I supposed to wait for another attorney? Is the court going to give us some guidance on how to move all this information from one law office, the court? I did. Mr. Rossi, to another, the court. When I granted the state's protective order, the thing I think the last paragraph of that protective order directs you to return all to the state of Indiana, all copies, all of the whatever you gave them, they are required under that order to return to you. Mr. Rossi, at the conclusion of the case, the court, or your representation. Mr. Rossi, I know what order you're talking about. I read the order before I came today. The court, okay. Mr. Rossi, so we're just to take everything back and give it to the state and then just retain our work product until someone asks for it? The court. Your work product is your work product. I mean, I would hope that you would share that with your successor counsel. I would hope that you would help your successor counsel just with the transfer of all the information because that's in your client's best interest to do that. But that's entirely up to you. That's your work product that you developed. I mean, clearly the discovery is required to go back to the state. Mr. Rossi, okay, thank you. What do you want to do with Mr. Allen? The court. I can transport him back to the Department of Correction. Mr. Rossi, do you want to make a record with his I think it's appropriate that the court let him speak into the record his thought unless the court just accepts that as notice that these are his opinions. The court, "Well, you wouldn't lie to me about that." Mr. Rossi, "I wouldn't lie to you about anything." Again, she does not care what Mr. Allen's, opinion is on this. She could care less. She went in there with a plan to kick these guys off and, come hell or high water, it was gonna happen. This is the most unethical, high-handed, ridiculous, backwoods, boss hog, you know, Game of Thrones, House of Cards, you know, Gordon Gekko kind of ridiculous crap I've ever seen. The court. So, of course, that's your representation that's what he would say if he were brought in here. I can't imagine the DOC being comfortable bringing him in my office, and I would not be comfortable having him in my office. What elitist bullshit. I mean, you are here deciding a man's life. You are supposed to be the representation of blind justice. You are supposed to just be the arbiter of the law. You are supposed to be making neutral decisions based on how you see the law. You are supposed to see him as not guilty, as innocent. You are supposed to be having an innocent man. You are supposed to see him as an innocent man. So if an innocent man comes to sit in your office, you shouldn't have a problem with it. Mr. Rossi, would the court also be inclined to mark as an exhibit the prepared statement so it's part of the court? The court, I have the record rolling. Mr. Rossi, okay. The court, yes. Mr. Baldwin, so we're going to leave, I guess, and you're going to, how is this? You're just going to get up on the bench and say, the court, I will just indicate to Mr. McClelland is going to be there with Mr. Luttrell, and I'm just going to say we've had a turn of events and the defense counsel is withdrawing. That's all I'm going to say. Mr. Baldwin, can you wait for us to get out of here? The court, of course. And we can have you, I don't know where you're parked at. We have a hearing set for October 31st, and I'd like to keep it as trial setting an appointment of new counsel, and if you can get things together by that date and return to Mr. McClelland, that would be good. Otherwise, with your permission, I will give successor counsel your contact information. Mr. Baldwin, okay. Mr. Rossi, okay. The court, where are you parked? Mr. Rossi, nice to meet you. Sorry, inaudible. Luttrell, inaudible. Mr. Baldwin, I'm not going to tell everyone where they're parked. Let's see. The court, everyone is in the courtroom, so I don't think that there's anyone in the hallway. Mr. Rossi, I'm going to get a staff member. I'm going to have her, I don't need any, we'll rendezvous at some point and try to get the stuff back. Mr. McClelland, okay, that's fine between Steve and Sarah and you. Mr. Rossi, okay. Mr. McClelland, we'll get it all. Mr. Rossi, that's fine. Mr. McClelland, done. That's either Sarah, Mr. Rossi, thank you. The court, thank you. This concludes the proceeding had in camera on October 19th, 2023 in this cause. Again, this has to be the most awful thing I have ever read as far as just this judge has gone out of her way to tip the scales of justice. She obviously has been talking to the prosecutor. They had this thing all set up before the defense got in there. This is not how any of this works. There are processes. So these things don't happen because judges can tip the scales of justice in a way that our politicians can't. I mean, a corrupt judge can cause more havoc, you know, than a corrupt politician, if you think about it. I mean, imagine how many times she's just put a little bitty finger on that scale, you know, in her courtroom. I mean, how many times has she done one of these things? How many times has she called someone into chambers and asked them to quit or asked them to change something just a little bit? Or she had, someone she didn't agree with, and she denied a motion. I mean, I don't know, but that is the transcript. Hopefully, I kind of gave you a good overview and you made it a little bit more clear of what was going on that day. And next, we will be going over some of the, filings that Judge Gull has made, that the state has made, different things in the Supreme Court. I know that they have made another arrest in the leaks, so I will be making a short video about that next. But I hope you enjoy this. I know it's a long one, but, you know, it definitely is eye-opening about, kind of the fact that, again, they ambushed these guys. You know, the defense attorneys thought they were coming in to do actual defense work, and they weren't. They were going there to basically be told, "You are either going to step down or I will publicly, pants you." So, I hope you will have a better day than they did on, October 19th, and they are fighting the good fight, so I hope you fight the good fight and have a wonderful day. I will see you tonight for Newsy News. Have a you know, have a good day. Say something kind to yourself and something kind to others, and I will see you in a little bit for Newsy News. Bye, guys.